The House will please come to order. So I know the room here looks pretty sparse, but there's a full room virtually. So thank you to our virtual participants for being present. There's still some bill signings going on. So that's where some of our colleagues are. So there's gonna be a privilege of the floor, and the remaining members on the floor better make some noise because we're gonna introduce some folks. So Representative Hunt.
Thank you, Mr. Speaker. Privilege of the floor.
Please proceed.
All right, thank you, Mr. Speaker. Folks, if you turn your attention to the North Gallery, we have from Lovell, the Lovell FFA chapter. They're down here for the state FFA convention. And as most of you probably know, last year, as I understand it, the convention was basically canceled. And so due to COVID, so they've been able to reconvene this year. And I hope Representative Flitner can see us. Yep, there she is. Upper right of your screen, or upper left, I'm sorry. But anyway, welcome to Lovell FFA chapter.
All right, welcome to the House. Good luck with all your activities this week. We're so glad you're here joining us today. So Conference Committee, House Bill 173, Barlow Chair, Summers Simpson. And I don't have a meeting time yet. So members, for the chairman of committees, please let's announce when your committee might be meeting. And if it gets announced and posted online by one house or the other, that works, but let's try to announce it in both ends. So hopefully here in the next 20 minutes, we'll get a whole bunch of announcements of those 5 or 6 committees that were appointed earlier. With that order of business, JCC reports. First JCC report for us is message 382 on Senate File 75. Madam Minority Floor Leader Connolly.
Thank you, Mr. Speaker. I move the Joint Conference Committee 01 to Senate File 75, and I ask for your favorable consideration. Friends, if you remember, Senate File 75 was the bill that added the ability to have a stipulated protective order to our protective order statutes in stalking and domestic violence. A stipulated protective order is different than a regular protective order because the parties, the respondent and the petitioner, need not go to a hearing, need not have findings of fact, and need not have any admission. So if you remember, we had a good discussion on the Committee of the Whole about, in particular, language where a respondent may make a knowing and voluntary stipulation. And that discussion was about how to assure that the respondent did a knowing and voluntary stipulation. So on second reading, we came back with 2 amendments. The First Amendment added in that there needed to be a requirement that the respondent understood that there was a choice. Now understand that the way that this is written, that there is no obligation for a respondent to agree. But we added in a stipulation that there need be a recognition in writing of the choice between agreeing to this stipulated protection order or an evidentiary hearing. And an evidentiary hearing would require then that hearing and admission, et cetera. So that was the First Amendment that was passed. And then the Second Amendment that we passed was one where we changed the penalty that was associated with a first violation of the protective order in terms of stalking, right? So those were two very different amendments that we passed, that was the good work that we did. And when it went down to the Senate, they said, oh, don't muck with our bill. We like the bill the way that it was. We want to go to conference committee. And so what your conference committee decided is that we would accept the First Amendment and we would delete the Second House Amendment. That was the compromise, so that we would allow for more due process associated with making sure that the respondent understood that choice between the stipulated protective order and an evidentiary hearing. And with that, I ask for your favorable consideration.
Discussion on the joint conference, Representative Stiff.
Mr. Speaker, thank you very much. Members, you're probably familiar with my position on this. The amendment that you adopted on second reading to this bill said that if someone is going to agree to a no fault, no factual basis stalking order of protection, that a first violation of that would be a misdemeanor rather than a 10-year felony. With the conference report before you, if you vote to accept it, if you vote aye on it, then you're voting that if someone agrees to a no fault, no factual basis stalking order of protection, that if they violate it, they can be charged with a 10-year felony. And that's a huge, big hammer to hang over somebody. And I would encourage a no vote on this conference report. There's really not a reason for us to roll over to the Senate's position on this. It's really common. What this does is it ups the stakes for disputes with your neighbors, because it encourages your neighbor to run to court first. Because if your neighbor files a petition against you because you have done something over a series of course of conduct, maybe you've taken your snow blower and blown snow under their car, maybe you've had your lawn irrigate onto their property against their will, and you've done this repeatedly. Maybe every time you leave the house, you flip them a rude gesture, and maybe they make a rude gesture to you. If they go to, and let's imagine that's just the kind of relationship you have. It's not a good relationship you've got with your neighbor. You're rude to them, they're rude to you. If they go to court first, the judge is not allowed to enter a mutual stalking order of protection. The stalking order of protection only runs one way. That is, the petitioner, if they get a stalking order of protection, it applies to you, doesn't apply to them. So if you agree to that with your neighbor because you don't want to mess with the court process, you just say, okay, fine. Then your neighbor the next day, if they are taunting you, if they're making rude gestures to you, they don't have anything at risk. But if you make a rude gesture back to them, you can now be charged with a 10-year felony. And think about the contrast between that situation and how this bill treats sexual assault protection orders. Under this bill and under existing statute, if you sexually assault your neighbor and there's a sexual assault protection order entered against you, if you violate that, that's a misdemeanor. So what's truly, truly strange about this conference report and the bill as it stands right now is that you are legally in a more favorable position to sexually assault your neighbor than to make a rude gesture toward them. It's bizarre. It's very strange. It's not right. We can do better than this. This is not our best work. This conference report is not the best we can do. We can do better, okay? So I would encourage a no vote.
Thank you, Representative Stiff. That was your first time. Representative Oakley for your first time.
Thank you, Mr. Speaker. I would encourage an aye vote on the concurrence. We're talking about stalking orders of protection. I don't believe that it's even that should be put in the light of neighbor disputes. That's just not really what is on the table here. It's an important bill to pass. It is consistent with, with what is in current law, as far as the idea being, if you have a stalking order against you and you continue to stalk, these are the consequences. But as I said on the floor, I would say either way, it's just more important that we get the content of this bill so that judges, respondents, and victims are all able to take advantage of protecting their rights. So the bill is the most important thing. But I believe this was thought out, discussed, and I think it's appropriate. And I just ask for your aye vote.
Thank you. Any other member? First time, Representative Brown in the chamber, Representative Brown.
Thank you, Mr. Speaker. Feels kind of like you see those things back in DC where you're speaking to an empty audience here, kind of lonely. But ladies and gentlemen, I'd urge an aye vote on this as well. And the biggest reason I would urge an aye vote on this is we've heard a lot of hypotheticals that could potentially occur with this. And what you ultimately find out is these hypotheticals are just that. I don't anticipate that you're actually going to find, number one, a prosecutor that's willing or even has the intention of going for a felony count on something like this. And number two, you're probably not going to have a judge that's going to allow this type of charge to be brought forward, and he can toss these types of charges. I mean, these are not overly glaring situations. And let me remind you that stalking is the number one issue when you start having stalking protection orders here. That's when you start having the precursor, typically the precursor to any type of homicides. We want to protect these people. And if you have a stipulated agreement with this, we want to make sure that those stipulated agreements are just as safe as ones that are issued from the court. And that's what we're doing with this. We're saying that if you enter into this agreement, you knowingly and willingly, and with the amendment that we've also kept in here, you've also been advised of what you are signing, that you should be held to the same standard that as if the court issued this order. There is personal responsibility in this. Plain and simple. You know what you're signing. You know what you're getting into. There's no sense in saying, well, we're just going to give you a misdemeanor this time. If you do it again, we're going to come after you. No, these actions have repercussions. And that's what we're trying to make sure we do here is we ensure that those repercussions make sure that we keep our people safe. Make sure that the people that have the true issues here are not the ones that have to worry about whether or not a misdemeanor is going to infuriate somebody further and then push them up and over the edge. We want to make sure that these people understand that these stipulated agreements have the bite of law, and that's exactly what this amendment does. I appreciate the conference committee bringing this bill back and with the information that we have with it, and I would urge an aye vote. Thank you.
Thank you. Any other member? First time on Joint Conference Committee number 1. First time. Representative Jennings.
Thank you, Mr. Speaker. So on and against this, I still have concerns with this, and that I think the previous speaker just kind of made the point of my uneasiness. Is this is stipulated? This isn't the full blown picture of due process, and so on and against this.
Thank you. Any other member? Representative Gray, first time.
Thank you, Mr. Speaker. I'm also going to be voting no. I think the amendment was a pretty important amendment on this bill, and it's disappointing that the committee didn't adopt it. And so I think we should go back and talk about this again. So I'd urge a no vote. Thank you.
Okay, other members for their first time? Any members for their first time in the chamber, online? Any members for their first time? Second time, Representative Stiff.
Mr. Speaker, thank you. I do want to address the statements that disputes between neighbor is, quote, not what is on the table here. And then the other speaker who said that these are just hypothetical, hyper-technical concerns. You might want to ask yourself, why do we even have this bill? Why is the bill here? The bill is here because of a specific case in my county where a prosecutor with apparently too much time on his hands actually did prosecute a person with no criminal record who had committed no crime. and charged him with a 10-year felony. Charged him with a felony, and there was no factual basis for the entry of the stalking order of protection. The party, the respondent, had appeared in court very quickly without a lawyer, and frankly got talked into agreeing to a protective order. And frankly, the protective order, as the respondent understood it, was something that he had no intention of violating. And in fact, he did not violate, but the protective order was written in such a way that you could plausibly think it had been violated. So then this person who has no criminal record, is a school bus driver, now finds his picture on the internet as being a person charged with a 10-year felony. Damages his reputation. He has to pay thousands of dollars. Appears in front of a circuit court judge who says, that's too bad. You have to go explain it to, you're going to get bound over for a felony. He gets bound over into district court. And then in district court, the only reason it got dismissed was because there was no factual basis that he had ever engaged in stalking. And because there was no factual basis that he had ever engaged in stalking, he could not be charged with a 10-year felony for a violation of a stipulated stalking order. Okay. Currently, stipulated orders can be enforced by the judge through contempt. Okay. I think it would be appropriate, frankly, to have a slightly stiffer penalty. I think it would be appropriate if you agree voluntarily to an order being entered against you, you should respect that. And if you violate it, it should be a misdemeanor, as it is a misdemeanor if you violate a sexual assault order of protection. But to raise the stakes and say that in this stalking area, that if you violate the order that you've agreed to, for which there may have been for which there's no found factual basis to start with, that it's a 10-year felony, really raises the stakes. And I think doesn't make society safer. What it does, it just makes people less trusting and more fearful of their neighbors. What is odd about the stalking statute is that it doesn't just apply to intimate partners. One of the very first Wyoming Supreme Court cases that interpreted this stalking statute in the 1990s dealt with two people who were not, romantically involved, people who were just neighbors who didn't get along with each other. All right. So that kind of stalking can happen. Our current law does deal with that. My point here is I think it goes too far to have a stipulated order for which there's no factual basis being the cause for having a 10-year felony hammer hanging over you. So thank you so much for your patience. I know we're all tired at the end of the session. I appreciate you listening to this argument for the third or fourth time, but please vote no and we can get a free committee to fix this. Thank you.
Thank you. Any other member for the second time? We're on second time. Second time, Representative Gray.
Thank you, Mr. Speaker. I just want to note, I really haven't heard why the amendment was dropped, and I thought the amendment was important. And so I really urge a no. Thank you.
Any other member for their second time? Second time? There you go. Second time before the conference committee chair, Representative Conley, Madam Minority Floor Leader.
Thank you, Mr. Speaker. We want to go back to what the point of this bill was. And if you remember, and if you take out your bill, the point of the bill was to add in the possibility for a stipulated protection order. That's it. Right now, we can have protection orders. Protection orders, again, they require evidentiary hearings. A stipulated protective order doesn't, right? It requires the parties to agree. It is not mandatory. The language in the bill is a respondent may, right? So that's all that was in the bill. If you remember again, our floor debate was wholly about the first sentence here, about a respondent may make a knowing and voluntary stipulation. We were concerned about what it meant to make a knowing and voluntary stipulation. So the First Amendment, the one that the conference committee accepted, was what addressed the concern that was on the floor, that we wanted to assure more due process for a respondent. This bill did not talk about punishment. It just doesn't, right? That Second Amendment does. The concern that's brought up by the good attorney from the southwest portion of the state talks about reducing a penalty. Know that that penalty already exists for violation of a protection order, right? It's not changing the ability to have a penalty. It's just it's lowering it, right? A violation of a protective order has a penalty that's associated with it. Again, not addressed in the bill. That's why your conference committee chose to listen to this body, which was concerned about due process on our debate. So that's why your conference committee accepted the First Amendment and then deleted the Second Amendment. And with that, I would ask for your aye vote. Thank you, Mr. Speaker.
Thank you. So members, we are voting on Joint Conference Committee number 1, report to Senate File 75. A majority of the elected members is required to adopt the report. Chief Clerk, please call the roll.
Andrew. Baker.
No.
Banks. Bear. Blackburn. Brown. Burkhart. Burt, excused. Clausen. Clifford.
Aye.
Connolly. Crago.
Aye.
Duncan. Eklund. Eklund, excused. Air.
Aye.
Flitner.
Aye.
Fortner.
No.
Gray. Greer, excused. Hallinan.
No.
Haroldson. Harshman. Harshman. Heiner.
No.
Henderson. Hunt. Jennings. Kenner.
Aye.
Knapp.
No.
Larson Lloyd. Larson Dan.
No.
McGuire. Martinez. Nyman. Newsom. Nicholas. Oakley.
Aye.
Obermuller. Obermuller.
Aye.
O'Hearn. Olson. Ottman. Paxton. Provenza. Roscoe.
Aye.
Schwartz.
Aye.
Sherwood. Simpson. Summers. Stith.
No.
Stibar. Sweeney. Walters. Washit. Excused. Western.
Aye.
Wharf. Williams, excused. Wilson. Winter. Yin. Zawanitzer. Mr. Speaker. Harshman. Excused. Closing vote. Are there any changes? Closing vote. The vote is closed. 29 aye, 25 no, 6 excused.
By your vote, you have failed to adopt Joint Conference Committee number 1 report to Senate File 75. So just be clear, members, on a joint conference committee, it's the majority of the elected members, not a majority of the quorum. So this is like a final vote. Obviously, there's an opportunity for an open committee, and we'll decide at some point if that's something that people want to pursue or not. Privilege? All right, so I'm going to take a quick privilege of the floor. And so many of you know Ms. Karen Hayes, who works down in the governor's office, and she happens to be a very proud grandmother. And her grandson, Andrew Johnson, so go ahead and stand up, Andrew, so the body can see you. is a senior at Central High School, and he just received a 5-year UW football scholarships to play safety. He's here with his mother, Rochelle, and the sister also attends UW, animal science major, UW ranch horse team. So Andrew, grandma, mom, congratulations. Welcome to the house. Congratulations, grandma and mom. And Andrew, you got a pretty good fan club there. I can tell you that. So great to have you here today. Do I have any conference committees that want to announce meetings? I've got several that I sure would appreciate them announcing them. Chairman Nicholas, Chairman Wilson, Chairman Brown, Chairman Hunt, Chairman Wilson.
Thank you, Mr. Speaker. Well, we weren't in session when we first met. So your conference committee on House Bill 127 did meet at about 40 minutes ago, and we are in recess until 9:30 tomorrow morning to allow the other end to think about it.
You are meeting at 9:30 tomorrow morning, and where are you meeting?
Mr. Speaker, if room, that room in the southwest corner, whatever it is, W110, if it's available, we'll go there. We had to kind of wait in line this time.
All right, thank you very much. 110, Chairman Brown.
Thank you, Mr. Speaker. Your committee, Joint Conference Committee number 1 for House Bill 158 met briefly and is currently awaiting a draft amendment. We will be meeting shortly upon adjournment, likely going to be down in one of the far west rooms down there to have a brief conference, but I think we're pretty well just waiting for the amendment to be seen. Thank you, Mr. Speaker.
All right, so continue, Chairman Burkhart.
Thank you, Mr. Speaker. Your Joint Conference Committee on Message 406, excuse me, House Bill 254 will meet tomorrow morning sometime. We're working on an amendment, haven't set a time or a place yet.
Go ahead and set a time and a place just in case, please. How about 9:45 in room W110?
Mr. Speaker, it'll be 9:45 in room 110.
Thank you very much.
West 110.
Thank you. So members of the public, this is our rules, is we do announce where conference committees are going to meet and when they're going to meet. And so that's why I know we're talking to our colleagues and we're trying to come up with the right language, but we also do this process in public. And so let's continue to work on that. Chairman Hunt.
Thank you, Mr. Speaker. Your Joint Conference Committee number 1 on House Bill 36 will be meeting in downstairs in 113, I believe, at 5 o'clock.
Thank you very much. Chairman Olson.
Yeah, thank you, Mr. Speaker. Your committee on message number 434 on Senate File 38 met briefly. We have an amendment being drafted. It is kind of lengthy, so we will meet again. Depending on, I was hoping that amendment would come to me and we'll be able to meet upon adjournment, but it doesn't look like we have it quite ready yet. So we will be meeting tomorrow morning at 9:45 a.m. in E001. Thank you, Mr. Speaker.
Thank you. Chairman Nicholas.
Similarly, Mr. Speaker, your Senate Council number 1 for Senate File 121 will meet at 9:30 in room 113 tomorrow morning.
And Chairman Nicholas, did you have one on Senate File 118? Or is that Senate File 118? And I have 2 down here with your name by them. Thank you.
Mr. Speaker, Senate File, the Joint Conference for 118 met. And we are awaiting the final draft and signatures. So
you were going to meet like at 9:20 tomorrow morning in the same room, right?
No, that's done. We've met and we have a concurrence. We're just waiting for the document, for the signatures on the parts. So
All
we
right.
noticed that earlier this morning.
Thank you. Chairman Summers, do you have any update on your conference committee? Chairman Summers.
Mr. Speaker, thank you. On the Charter School Bill 130, I think we've came to a probable compromise, but until it's signed, I'm not gonna say anything because it could revert in an instant. So, but I think we're getting close on that one.
All right. Any other conference committees? I think I've got everybody ticked off except the revisers bill. And I think if I explained that earlier, that we're going to wait till the last of the last, go to an open committee so we can bring in a couple of things that staff have found. And then 173 as well. And I'll get with my colleague down the hall to place a time for that. All right, messages from the Senate.
Message 447. Mr. Speaker, the Senate appointed Senate conferees to meet with the Light Committee number 1 from the House on amendments to House Bill 92. The Senate conferees are Senator Hicks, Chairman, Senator Driscoll, Senator Steinmetz. Sincerely, Ellen Thompson, Senate Chief Clerk. Message 448. Mr. Speaker, the Senate appointed Senate conferees to meet with the Light Committee number 1 from the House on amendments to House Bill 127. The Senate conferees are Senator McGowan, Chairman, Senator Nethercott, Senator Steinmetz. Sincerely, Ellen Thompson, Senate Chief Clerk. Message 449. Mr. Speaker, the Senate appointed Senate conferees to meet with the Light Committee number 1 from the House on amendments to House Bill 158. The Senate conferees are Senator Boner, Chairman, Senator Baldwin, Senator Driscoll. Sincerely, Ellen Thompson, Senate Chief Clerk. Message 450. Mr. Speaker, the Senate appointed Senate conferees to meet with the Light Committee number 1 from the House on amendments to House Bill 254. The Senate conferees are Senator Landon, Chairman, Senator Furphy, Senator Salazar. Sincerely, Ellen Thompson, Senate Chief Clerk. Message 452. Mr. Speaker, the Senate appointed Senate conferees to meet with the Light Committee number 1 from the House on amendments to House Bill 173. The Senate conferees are Senator Scott, Chairman, Senator Ellis, Senator Steinmetz. Sincerely, Ellen Thompson, Senate Chief Clerk.
We're not that order of business at the signing of enrolled acts. First enrolled act is enrolled act number 80, House.
House Enrolled Act 80 being original House Bill 163. An act relating to elections, modifying the definition of residence for purpose of elections of the candidates for the offices of the United States Senator and members of Congress, modifying nomination application requirements and affirmations accordingly, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign enrolled act 80 being original House Bill 163. I have so signed. Congratulations, Representative McGuire. Next enrolled act is 81.
House Enrolled Act 81 being original House Bill 136. An act relating to elections, amending the use of pronouns on the ballot and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign enrolled act 81 being original House Bill 136. I have so signed. Congratulations, Representative Yin. Next enrolled act is 82.
House Enrolled Act 82 being original House Bill 51. An act relating to the emergency expenses of government, authorizing a governmental program related to expanding and enhancing meat processing capabilities, providing for an appropriation, providing a sunset date for the program, providing rulemaking authority, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign enrolled act 82 being original House Bill 51. I have so signed. Next enrolled act 83.
House Enrolled Act 83 being original House Bill 231. An act relating to post-secondary education, creating provisions governing how previously completed coursework may be used to earn a post-secondary degree or certificate, authorizing a student petition process and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 83 being original House Bill 231. I have so signed. Congratulations, Representative McGuire. Next Enrolled Act 84.
House Enrolled Act 84 being original House Bill 219. An act relating to the investment of state funds, amending the membership of the Investment Funds Committee, amending the voting privileges of members of the Investment Funds Committee, providing for the removal of members, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 84 being original House Bill 219. I have so signed. Congratulations, Chairman Nicholas. Next Enrolled Act 85.
House Enrolled Act 85 being original House Bill 244. An act relating to public funds, providing for a study and report regarding alternate measures for managing the investment of state funds, making legislative findings, outlining issues to be covered in the study and report, providing for recommendations for a plan to provide for alternate measures, providing for filing of the report, providing for staffing and requiring assistance by state executive and legislative entities, providing an appropriation, providing for subsequent legislation, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 85 being original House Bill 244. I have so signed. Next House Bill, or next Enrolled Act 86.
House Enrolled Act 86 being original House Bill 22. An act relating to defense forces and affairs, amending and updating the state military code, repealing provisions, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 86 being original House Bill 22. I have so signed. Next Enrolled Act 236, or excuse me, Enrolled Act 87.
House Enrolled Act 87 being original House Bill 236. An act relating to banks, banking and finance, prohibiting financial institutions from discriminating against firearms businesses, specifying civil remedies, providing for attorney's fees and costs for successful action, providing a statute of limitations on civil actions, providing for potential loss of state business to a financial institution found to have violated this act, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 87 being original House Bill 236. I have so signed. Congratulations, Representative Washington. Next Enrolled Act is 88.
House Enrolled Act 88 being original House Bill 166. An act relating to public utilities, creating a presumption against the retirement of electric generation facilities as specified, providing definitions related to the presumption, specifying how public utilities can rebut the presumption, limiting rate recovery for public utilities, retiring electric generation facilities without rebutting the presumption as specified, requiring consideration of reliability before approving the retirement of an electric generation facility, requiring rulemaking and providing for effective dates, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 88 being original House Bill 166. I have so signed. Congratulations, Chairman Harshman. Next Enrolled Act 89.
House Enrolled Act 89 being original House Bill 253. An act relating to the University of Wyoming and community colleges, prohibiting the University of Wyoming and community colleges from expending funds on abortions or insurance coverage for abortions as specified, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 89 being original House Bill 253. I have so signed. Congratulations, Representative Gray. Next Enrolled Act 90.
House Enrolled Act 90 being original House Bill 189. An act relating to mine product taxes, clarifying the imposition of severance taxes on natural gas that is consumed on site, making conforming amendments, requiring rulemaking, and providing for effective dates, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 90 being original House Bill 189. I have so signed. Congratulations, Representative Hunt. Next Enrolled Act 91.
House Enrolled Act 91 being original House Bill 159. An act relating to the regulation of alcoholic liquor, amending the number of satellite locations for liquor manufacturers, conforming provisions, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 91, being original House Bill 159. I've so signed. Congratulations, Vice Chair Duncan. I guess we know who's buying tonight. All right, Chief Clerk. Mr. Majority Floor Leader. Mr. Majority Floor Leader.
Mr. Speaker, I move the House adjourn until tomorrow, the 7th day of April at 10 a.m. 2021.
Thank you. Committee announcements. Conference committees have all been announced with the exception of the one. So members, tomorrow will be our 34th day of the 66th Wyoming Legislature. It'll be Wednesday, the 7th. Our intention is hopefully to have conference committees to be able to report out with reports first thing in the morning. A bunch of them are meeting between 9 and 10, so that's why we didn't start any earlier. So we'll have some things. We'll probably take a break for till 11. When we get that done, take a break until maybe 1 or 2, and hopefully we can get things back and forth from each end. We can be done by mid to late afternoon tomorrow. That's our best intentions. That's our best hopes. So I thank you to all the members who joined us online today and made our quorum a very solid quorum. Thank you to all the members here. So all those in favor of the majority floor leader's motion that we adjourn until 10 a.m. April 7th. That will be our 34th day of the session. All those in favor, please say aye.
Aye.
Those opposed, no. We are adjourned. We are adjourned until 10 a.m. the 7th. Thank you very much and good work.